Sued but not yet served. What to do if you know a debt lawsuit has been filed against you but not served on you yet. Brought to you by yourlegalagup.com, your advantage if you're being sued by debt collectors. Sometimes people find out they're being sued before the plaintiff gets around to serving them. How does this happen, and what do you do if that happens to you? People can learn about a suit before being served. It is public knowledge, after all, so it could happen in a lot of different ways. Mostly, though, it happens in one of two ways. Sometimes debt collectors bug you for money, and you go out of your way to check court files to see if you're named in a suit. Or a neighbor could see a process server and ask what's going on and then tell you what they hear. And I guess most of these things don't happen that often, but they can happen, and they do sometimes. The other way is more common. There are lawyers who want to represent people in these cases, and they may send you a letter telling you you're being sued. It may be news to you that anybody's even after you, much less actually suing you, so you check the court files and find out it's true. What do you do then? There have been times people brought these cases to me and wanted to take action, back when I was practicing. At that point, they had a lawyer and a counterclaim, usually, and where that's the case, it can make sense to waive or to let go your right to service and just enter on the case and get down to business. We were sure we'd win, and we had a counterclaim, so why wait? And we often didn't. If you're pro se these days, the situation is very different. You can't be sure you'll win, however much you think the facts are on your side, because you can't count on the courts to see it your way. No matter how clear you think it is, you just can't count on winning. That's my opinion. And you're less likely to have a counterclaim these days because the courts have narrowed the definition of debt collector. So for these reasons, I think it makes sense to take no immediate action, but to watch the court docket without identifying yourself to the court to see if they ever claim to have served you. Or until they actually do serve you, of course. You have no obligation to make it easier for them to serve you, and if they can't get you served, they will eventually have to drop the case or get it dropped for failure to prosecute. I think it makes good sense to give them that chance. But watch to make sure they don't claim you were served, and likewise if they serve by publication, which is putting an ad in a small local paper, you'll probably need to answer. But that's rare, and they have to get special permission to do that, so watch for that. You need to keep an eye out for tricks mostly. So watch and see if you get lucky and have them drop the case. That could happen. Or they'll figure out how to get you served, and then you'll have to defend. You won't have lost anything by waiting to see if they can serve you, though. And obviously, if you do have to defend, we can help. Helping people protect their rights is what we do. Protect what's yours, and don't let the debt collectors rip you off. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe, and comment, as all these things help people find our materials. yourlegalagup.com